This decision today is a landmark ruling in defense of Americans' privacy rights in the digital age. The court strongly rejected the government's argument that just by using modern technologies and just by our sensitive data being held by the companies we interact with rather than on our own devices or in our own homes, we give up our privacy rights. Well, this ruling most directly makes clear that when the government, in investigations of people, wants to see where they've been in the past by looking at their cell phone location data, they have to get a warrant based on probable cause. Our argument was that when police went to a cell phone company to get Mr. Carpenter's cell phone location records covering nearly 4 months, they should have gotten a warrant based on probable cause because these records are so sensitive and so private. So the Supreme Court decided that his Fourth Amendment rights were violated and sent the case back down to the lower courts to decide whether the evidence that violated the Fourth Amendment should be thrown out and potentially whether the other evidence in the case is enough to sustain a conviction. The Supreme Court said nothing about that question, and that'll be addressed in the next stages of this case. Today, it's not only our cell phone location data that companies hold, but it's things like the contents of our emails, thousands of types of data collected by apps on our phones, medical information from those apps or from a smartwatch that's uploading to the cloud, information about the interior of our homes from so-called smart devices like a smart thermostat that knows when we're home or a smart assistant that hears our voice talking to it. It is absolutely crucial that we be able to live as 21st century Americans without giving up all of our privacy rights under the Constitution, and that's what today's opinion allows.